Yes.
And how did you acquire these materials?
It was fairly easily. I knew one of the employers or employees of MyTwitFace, which is British, and I knew he used a very simple password scheme based on his pet's name, Snuffleupagus.
Snuffleupagus? What kind of pet is that?
I don't know. I've never seen it.
So you just used that name, typed it in?
Yeah, just did minor substitutions for letters, for numbers, and things like that.
Okay, and then so
or vice versa.
You got inside, and well, we just had the description of how it occurred from the expert. Why did you do this?
Because there are millions of users that were having their data used against their will, and I felt that everybody needed to know about the exploits of this douche nozzle sitting over here.
And you were familiar with him from your days at MyTwitFace?
Oh, yes, I was. He was the oldest.
Objection, Your Honor. That's just not nice. Could you please advise the witness to be nicer?
I overrule that. Encourage hostility.
Okay. Well, so why not just go public with what you knew as a former employee, and not do the video and the screenshots?
I felt I needed hard proof so that it wouldn't be just another blank accusation or unfounded accusation.
And then after this controversy arose, a lot of controversy, was there not?
Yes.
And then users increased at via-a-vis after this became public?
Yeah, subscription increased by 75% the first month, and my friends list doubled.
Oh, okay. But do you make any more money?
No, I did not.
So the more users there are, that doesn't affect how much money you make?
No.
The more friends that you have doesn't affect the more money you make?
No.
Did anyone pay you to conduct this exploit?
No, they did not.
Are you aware of any plans to monetize via-a-vis?
No, we have no plans to monetize Aspera. We've promised to our users that we would never use advertising, we would never share their information. Its sole purpose is to promote free speech and sharing of Farmville assets.
And anyone is free to download the code and make a competitor with you using the same code?
Absolutely.
Did you expect to receive anything at all, anything of value out of this hack?
Out of the attack? No, I just wanted to expose this asshole's evil plan.
Yeah, that one's okay. That's accurate. It was the early one.
Well, I understand you have strong feelings about the CEO and that this was... but were you doing this to hurt MyTwitFace?
Not so much. I just wanted people to know the truth. Then they could basically make their own decision.
No further questions.
So it's Mr. Weasel, is that correct?
Yes.
Okay. Mr. Weasel.
Mr. Weasel, period. My last name is period.
Okay. Mr. Weasel, period. My last name is period. One of the pleasures of preparing for this case is I got to watch the video of you speaking at the Fred conference. That was really an impressive show you put on.
Thank you.
Seemed like a really good conference. Did you have a good time there?
Yeah, it was a great conference. It's much better than TED. It's +1. TED +1.
And as we heard in earlier testimony, it sounds like they gave you a pretty substantial sum of money to speak at Fred.
They gave me money to cover my expenses, yes.
It sounded from earlier like we were talking about more than just reimbursing expenses, weren't we? This was an honorarium. This was a $5,000 check.
My expenses are high.
And do you think you would have received that invitation were it not for this big privacy controversy?
Objection. That calls for speculation.
If you rephrase the question into a motive question, we might allow it.
Okay. So let's talk about your history with Fred. Had you been invited to Fred before?
No.
And so this unprecedented invitation came immediately after the news broke, correct?
There was a day.
And when the invitation came, the person who invited you specifically asked you to talk about this big privacy controversy. Isn't that correct?
Yes.
And aren't you now better known than you ever were before any of this ever happened?
Yes. Well, yeah, I get more emails.
Do you get more emails, invitations, things like this?
Sure.
And then you also testified further that in the first month after this happened, your user base increased 75%. Is that correct?
Yes, in the first month.
So criminal actions that you took led directly to more money for your project. Isn't that fair to say?
Mischaracterizing the testimony.
All right, let me rephrase this. That's okay, Your Honor. You disclosed the video. You published this information to this journalist. This led to a lot more users on Vaporaspora for a project for which you are the lead coder. Is this correct?
No, not so much so. I don't agree with that. I think that the users came because of the effect on the being exposed to the effects of their privacy, not because of anything else that I did.
All right, we'll let the jury decide that. Thank you, Your Honor.
Any redirect? The witness is excused. Defense, do you have any other witnesses?
No, Your Honor.
All right. Are there any other issues that we need to raise outside the presence of the jury?
Yes, Your Honor, there is.
Proceed.
Defendant, again, like to bring a Rule 29 motion, renewing our motion for acquittal. And in particular, we would like to move for acquittal on count 2 regarding interception of electronic communications. Based on the definition of electronic communications in the wiretap statute, the wiretap statute only protects communications, electronic communications, such as instant messages, that are, quote, transmitted in whole or in part by a wire, radio, electromagnetic, photoelectronic, or photo-optical system that affects interstate or foreign commerce, end quote, such as the internet. However, much like a key logging device, which does not capture communications being transmitted over the internet, but only the keystrokes being transmitted between a keyboard and a computer CPU, the exploit here did not intercept Mr. Zuckerson's instant messages with his friend, which were transmitted over the internet, but only acquired those communications that were purely internal to Mr. Zuckerson's computer, between his screen buffer and his monitor. Hence, this jurisdictional prerequisite that the communication at issue be transmitted over a system affecting interstate or foreign commerce was not met, and no electronic communication, quote unquote, was ever acquired. Only communications between components of Mr. Zuckerson's computer. I think this conclusion is mandated by the reasoning of US v. ROP, a 2004 case concerning key logging, that we believe was correctly decided by the Central District of California. There, Mr. ROP was indicted for attempting to intercept the communications of a coworker in violation of Title III of the wiretap statute by installing a device called a key catcher on the cable that connected her keyboard to her computer's CPU. And that device recorded the keystrokes transmitted between the keyboard and the computer. The court in ROP concluded that even though the victim's computer was connected to the company's network, which qualified as a system affecting interstate commerce, and even though the keylogger captured keystrokes used to compose emails and other communications to be sent over that network, there simply was no interception in that case, because the only communications captured were the internal communications between components of the computer that occurred prior to the transmission over the internet. Therefore, as the ROP court concluded, and I quote, the communication in question is not an electronic communication within the meaning of the statute because it is not transmitted by a system that affects interstate or foreign commerce. The system involved consists of the local computer's hardware, the CPU, hard drive, and peripherals, including the keyboard, and one or more software programs, including the computer's operating system, and either an email or other communications program being used to compose messages. Although this system is connected to a larger system, the network, which affects interstate or foreign commerce, the transmission in issue did not involve that system. The network connection is irrelevant to the transmissions of keystrokes between the keyboard and the CPU, which could have been made on a standalone computer that had no link at all to the internet or any other external network. We think this logic is compelling, and this logic applies the same in this case. The screen capturing exploit at issue here, like the key catcher in the ROP case, did not monitor communications going through the computer's internet ports and out to the broader internet, or from the broader internet, which is unquestionably a communication system affecting interstate commerce. At most, and independent of any transmissions made over the internet, The exploit captured only the transmission between the computer's video buffer and its monitor, transmissions that were completely internal to Mr. Zuckerson's computer. Therefore, those transmissions were not electronic communications under the statute, and any acquisition of those transmissions was not an interception in violation of the statute.
Do you have any additional argument?
I do not.
All right, thank you. Mr. Ohm, do you have an argument against
I
the
do, Your
motion?
Honor, and unlike last time, to use the technical term when I had my ass handed to me, the defendant has one case that it cites, and it's a case out of the Central District of California. And with all due respect to the court in the Central District of California, you know, I don't need to tell you that this is not binding on this court. This is just precedential. But that said, I'm happy and willing to explain why we, the government, believe that ROP was wrongly decided. And even if there is some internal logic to ROP, and we're not going to concede that, we also think that this case is distinguishable. So once again, what the defendant is doing and what the court in ROP did is it's elevating this strange formalism. So here we have Title III of the Wiretap Act, and it's supposed to be about the acquisition of the contents of certain kinds of communications. Now, of course, we are a federal system. This does have to, as the slide here indicates, involve a system that affects interstate or foreign commerce. But if you parse the language very closely, you'll see two very interesting words that I think we need to meditate on a bit more. One is the word affects, and one is the word system. Let's start with the word system. The defendant, if I'm following correctly, would have you believe that the only system that is protected is the network interface, the wire, and whatever network interface is on the other end. That the word system that Congress used but did not define can't be defined to include anything that happens on the other side of that network interface. That if the only thing we're talking about is the CPU, the video buffer, the bus, for some reason Congress decided that this comprehensive, expansive privacy law won't extend those 18 more inches into the computer. And we think this is just a facile argument, and we're very surprised that the court in California, in the Central District, embraced this. We think the better argument is that the word system means the entire system, the network. And I think, again, doing as I did a second ago, references to an ordinary English dictionary about what the word system means would bear that out. That the word system is broad enough to show that Congress meant not just two cups and the string in between, but it can also be the computer on the other end. That's our first argument. Our second argument is that the word affects, even if you're willing to take a narrow view of the word system, the word affects gives the court the opportunity to understand that Congress meant something that is broader than just a narrow definition of system. And for this, I will actually point you to other district court authority we think is much better reasoned. This is Potter v. Havlicek out of the Southern District of Ohio. This is a court that was decided after ROP, cited ROP, and disagreed with it. And in this court, they said the ROP court misunderstood and misread the definition because they neglected the word affects. And even if we were to define the system to exclude the little bit, the 3 inches between wherever the video buffer RAM is held and the CPU, even if we're able to do that, this still affects the larger system. In this case, we're talking about instant messaging. The thing that was intercepted were the communications between people on an inherently worldwide internet-based network. And so it just doesn't make sense to read in this constrained way. The final thing I'll say about this is the Potter case also involved screen capture, like we're talking about here, unlike the ROP case, which was just keyloggers. And so there's a different dynamic about the types of messages that are stored and the types of messages that are intercepted. So for all these reasons, we urge the court to deny this motion.
Thank you, Mr. Ohm. Appreciate the briefing on this and the concise argument here. It's clear to me, and it seems conceded by both parties, that the communications that were acquired here were internal, that there was not a sniffing of the wire to pick up communications as they left a device or were transiting to another device. And as a lifelong judicial official, I'm very familiar with the internal workings of computers. But I do think that the question here is really one of a fact for the jury to decide. First, whether this actually affects interstate commerce, And second of all, whether the system is broad enough, the term system